Well, it's truly wonderful to be back here at the Stigler Center. 5 years ago, as Tommaso indicated, I attended the Center's inaugural antitrust conference and competition conference. And the first conference asked an important question: is there a concentration problem in America? In retrospect, that particular conference functioned as a critical inflection point in the conversation regarding corporate concentration and the state of antitrust more broadly. A conversation that we're still having today, but against the backdrop of a dramatically different enforcement and political environment. I have vivid memories of attending the lunchtime keynote, much like this one, where Judge Posner quipped with a degree of seriousness and a bit of humor, antitrust is dead, isn't it? It was a provocative statement, to be sure, but a fair question, actually. Judge Posner was saying the quiet part out loud. Indeed, the purpose of the conference was in many ways to assess whether antitrust still had a pulse and whether it could be nursed back to health. Turns out that antitrust was not actually dead. If anything, the patient was on the table and receiving open heart surgery. I'm pleased to report that the patient is alive and well. The prognosis is good. Antitrust enforcement is on the mend, cared for and supported by a broad, bipartisan coalition devoted to its rehabilitation and full recovery. We're not completely out of the woods yet, though. Now we have a distinct opportunity, though, of charting a path forward. The good news is that which does not kill us makes us stronger. And I'm here to declare that the area of lax enforcement is over, and the new area of vigorous and effective enforcement of antitrust law is back, but the path will not be easier, nor will it be linear. With the remainder of my time today, at least the prepared remarks, and I look forward to answering questions from Tommaso in the audience, I would like to outline what I see as 5 pillars of effective civil enforcement. These are not exhaustive, and although I'm heartened by the productive discussions taking place in Congress to clarify our antitrust laws, Americans cannot afford to wait for new legislation to combat our competition crisis. These 5 pillars, which are by no means exhaustive, as I noted before, focus on enforcing the laws that we already have, as Congress wrote them and as courts have interpreted them for decades. First, recognize that the purpose of antitrust law is to protect competition. Second, change the language of antitrust so that it empowers all Americans to participate. Third, adapt antitrust to address market realities rather than relying on static models and assumptions. Fourth, revive enforcement of Section 2 of the Sherman Act. And fifth, litigate cases to decisions so that the law can develop. Each of these 5 pillars are worthy of their own discussion or perhaps conference, but I will take my limited time here today just to summarize them a bit, and then we can discuss as appropriate. The first pillar is to recognize that the purpose of the antitrust laws is to protect competition. The heart of our national economic policy, which is what the Supreme Court said in Standard Oil v. FTC, long has been faith in the value of competition. Yet somewhere along the way, the antitrust community lost its North Star. Over time, antitrust enforcement turned into a mathematical exercise focused on measuring welfare trade-offs rather than trusting in the benefits of competition. We took up the impossible challenge of quantifying often unquantifiable welfare effects and speculative efficiencies down to the last decimal point. On the basis of those calculations and projections, the antitrust community took it upon itself to decide who should win and lose rather than allowing competition and competitive markets to govern that determination. The problem, though, is that standards about measuring welfare trade-offs turn antitrust into a narrow and technical exercise that often overlooks the realities in our economy. Antitrust law is about so much more. To paraphrase the Supreme Court in Northern Pacific, antitrust promotes material progress, quality, and innovation. At the same time, it supports our democracy and preserves a society of choice and opportunity. Antitrust helps make us both prosperous and free. We usually cannot measure and quantify all of these values, of course, but we can promote them the way that Congress intended, by protecting competition and by protecting the competitive process. Instead, however, for years, scholars and pundits have expended enormous energy debating the meaning of the words that do not appear in a statute, the ephemeral consumer welfare standard. By my back-of-the-envelope calculation, about 831 academic articles have been written invoking the consumer welfare standard, with more than 200 since 2020. It's the academic gift that keeps on giving, and given that we're an academic environment, happy birthday. All of this is fine as an intellectual exercise, but there's just one problem. The phrase consumer welfare standard does not appear in any statute, legislative history, or common law precedents. The vibrant debate around the consumer welfare standard is an attempt to interpret words that are not actually in the law itself. Instead, the text of the antitrust laws reflect the value judgment by Congress to protect competition. For generations, Congress has continued to anchor our antitrust laws in a simple but powerful concept, that competition deserves protection. Congress prohibited agreements that restrain trade, mergers that substantially lessen competition tend to create a monopoly, and conduct that monopolizes markets. Where the Sherman Act's prohibition on unreasonable restraints of trade was general, Supreme Court explained that based on common law it invoked, it outlawed restraints that were, quote unquote, unreasonably restrictive of competitive conditions, close quote. The Supreme Court describes antitrust very much the same way, though there are 0 Supreme Court opinions that use the phrase consumer welfare standard. Instead, the Supreme Court has repeatedly described the purpose of antitrust laws as protecting competition. For each of the handful of times that the Supreme Court has mentioned that antitrust is a prescription for consumer welfare, it has dozen times reminded us that the mandate of the law is actually competition itself. And even when courts mention the welfare of consumers as a prescription, they do not declare it as the exclusive goal. Indeed, courts have articulated myriad benefits and goals associated with preserving competition and enforcement of the antitrust laws. Competition itself is the process of rivalry, and we see it play out in the markets and we participate in every single day as buyers, sellers, workers, and innovators. Focusing on rivalry and competition lets us decide the tough questions in particular cases as markets evolve. I've seen those that say antitrust does not protect our democracy argue that even though it was plainly Congress's intent, acknowledging that value in law would not be administrable in particular cases. I would say the same for assessing the allocative efficiency impacts of particular cases. We spend millions upon millions of dollars arguing about models of the economy and how conduct will hypothetically shift outcomes to the 4th decimal point up or down. Plaintiffs and defendants offer experts and present quantitative models. More often than not, courts reject both competing models and do not believe either side. The judges are onto something. Law enforcers and courts are not central planners, and they're not capable of consistently making those kinds of measurements. It's just not possible. Calculating welfare effects is difficult in non-dynamic markets and is increasingly impossible in today's multi-sided, cross-subsidized, and dynamic markets. We can, however, more easily assess how conduct or mergers impact competition and the competitive process. That is how the antitrust laws simultaneously serve prosperity and freedom and all their many values by preserving economic liberty and letting competition operate to organize our economy. That is not to say that promoting competition never raises tough questions, never requires debate, never requires expertise. Of course, there will be hard issues and hard cases. However, focusing on competition will ensure that we remain faithful to the underlying purpose of the antitrust laws, which is that a competitive economy is what yields innumerable benefits for a free, open, and democratic society. Congress has chosen the values we are to preserve, and it has squarely settled on upholding competitive process in free markets. Our job is to ensure a fair game, not to choose who wins. The good news is that promoting competition can be administrable and effective. That is why the first pillar in addressing competition, that is why this is my first pillar in addressing the competition crisis. We need to enforce the laws as we find them and vigorously protect competition as Congress demanded. That brings me to my second pillar. For too long, we have cloaked the antitrust laws in technocratic language. We must use the language of the people and markets to empower participation in the antitrust enterprise. Our competition crisis affects real people. These people are not numbers on a spreadsheet. They're farmers struggling to find competitive buyers for their livestock. They're travelers who cannot afford a plane ticket home to visit family members, or consumers who have little choice about who extracts and exploits their data. When we issue guidelines and speak only of small but significant non-transitory increases in price, or how vertical effects derive from, quote unquote, the elimination of double marginalization, we exclude these people from the antitrust dialogue. This language boxes the public out and the courts, frankly, of a critical discourse about how their economy is structured. The technocratic veil around antitrust has helped mask contortions of the law that undermine the foundational purposes of the antitrust statutes. How else can you rationalize a theory that monopolies and competition can coexist? Or that the establishment and maintenance of monopoly power are consistent with antitrust law? Using the language of the law and of real people, we can be clear. Merger to monopolies are always lessen competition. Monopolization always lessens competition. At the same time, a technocratic approach has made antitrust less accessible and less democratically accountable. Congress, the courts, and the people cannot engage with language that is accessible by a small segment of the population. Shielding the antitrust exercise from the public benefits only those with the money and power to hire experts and purchase access, and it shuts out other forms of expertise and real-world experience. Finally, our inaccessible antitrust system makes it harder for businesses to understand whether their conduct is lawful to begin with. The antitrust is supposed to empower businesses to operate to their fullest potential in an economy free from the threat of monopolists. But businesses cannot act confidently if they do not know the rules, or the rules themselves are so complex that it's impossible to rely on them with any degree of certainty. Of course, economics remains incredibly important, and so do other forms of expertise. But at the same time, you should not need a graduate degree in economics, no offense to our folks here, to understand the law. The challenge before us is to engage in sound reasoning, at the same time we re-engage the public with critical decisions that impact the structure of their economy. That is why one of my primary goals as Assistant Attorney General is implementing the division's Access to Antitrust initiative. We're calling it AT2J, think R2D2, but for antitrust. That means listening to the public. It means writing our guidelines in language that reflects how people understand them and how they understand harm to competition. For example, we recently published an updated FAQ to our leniency program. We have an ongoing review of the merger guidelines, and as part of that process, we're out there listening to all Americans, not just folks inside the Beltway, not just folks in academia. We're also listening to farmers, we're listening to grocery store owners, we're listening to doctors, emergency room technicians, nurses. These are the people who understand their markets the best, and we need to speak with them, and we need to give them a language and a taxonomy to speak back to us. The third pillar is to focus on competitive realities of today's markets. The digital revolution has brought about a change in our economy, a change that rivals the Industrial Revolution. We must acknowledge that new market realities demand new approaches to competition enforcement, and we need to update our tools to meet the facts, not try to contort facts to meet out-of-date tools. The changes in our economy are not confined to digital markets, of course. The internet revolution, the advent of big data, the new ubiquity of connectivity have transformed our entire economy, from finance to healthcare to energy to retail and so on. Now you can order your ticket online in advance, interacting with in seconds, or if not milliseconds, with dozen or more interconnected businesses across the economy. Businesses are harvesting more data as a result, and gatekeepers are growing in strength, and automated decisions are changing business paradigms forever. Just as our economy evolves, so must the tools we use to understand our economy. In the absence of evolving our tools, not only will we not be effective, we will be destructive. And that's often mean focusing on the facts when we examine competitive realities, as opposed to beginning with assumptions embedded in models. We need to start with how competition really works in a market, then extrapolate to whether competition would be harmed, a monopoly maintained, or created. It also means reassessing whether precedents are outdated because they reflect embedded assumptions of how assumptions about markets that may no longer hold true. Justice Gorsuch recently explained in NCAA versus Alston, analysis of competitive effects follows market realities, and so if those market realities change, so may the legal analysis. While enforcers and courts must respect Congress's core command that the antitrust laws should be applied to protect competition, how we do that must evolve as competitive realities themselves evolve. Antitrust enforcers must think critically about where their practices and where their cases are based on outdated assumptions. And in those instances, we must update how we approach law enforcement. Take Brook Group. There, the Supreme Court recognized a safe harbor for above-cost pricing, even when such pricing is exclusionary, based on what it characterized as the general implausibility of predatory pricing. A growing body of evidence suggests that above-cost pricing actually can be a rational strategy for anti-competitive exclusion, particularly in modern digital markets. We need to think about whether the assumption of general implausibility still holds in markets when companies often prioritize long-term growth of share price over short-term profitability. Strategies that may have once seemed implausible or irrational can yield eye-popping wealth for executives who earn way more from the value of their shares than they do from their salaries or bonuses. Different considerations drive decisions. That necessitates a change. Another example is the refusal to deal paradigm set forth in Trinco and Aspen. Modern online platforms are cooperatives. They're fundamentally participatory in a way that telephone lines and ski lists never were. Yet Trinco relies on the basic understanding about how networks are built and whose investment incentives are most important. If the nature of networks change, other parts of the analysis should change as well. That is the third pillar. We need to focus on markets as they exist today, and if conduct harms competition, the models and tools must adapt, not the other way around. The fourth pillar is to vigorously enforce Section 2 of the Sherman Act. Section 2 prohibits monopolization. But when we met here 5 years ago, it was probably the best illustration of Judge Posner's question. At the time, there had been no major Section 2 litigations to a decision in nearly 20 years. Section 2 was very near death. Senator Sherman warned that if concentrated powers of monopoly are entrusted to a single man, it is a kingly prerogative, inconsistent with our form of government. Yet we know now many such people who enjoy power over markets. Notwithstanding the original goals of the law, we have seen the emergence of monarchs over new industries in the digital revolution. Senator Sherman wrote the antitrust laws as a prescription. We must vigorously enforce the Sherman Act to prevent unlawful acquisition, maintenance, and extension of monopoly power. That means we must assess conduct on its merits and based on the entire course of the conduct involved. We need to use our tools to understand and assess how monopolies have arisen and how they're maintained. We must challenge conduct that suppresses and conduct that destroys competition. We also need to take more seriously the course of conduct that maintain monopolies. Gave remarks on this point a couple of weeks ago in Brussels. Monopoly maintenance in the form of moat building strategies helps protect the erosion of monopoly positions and therefore harms competition. We can no longer view individual acts in a vacuum. Digging a moat in the front of your castle cannot be considered a separate exercise than digging a moat in back of your castle, right? This is all interrelated, and for us to actually understand what's really happening in the marketplace, we have to have the willingness and the ability to connect related acts and understand how moats protect monopoly power and how competition presents itself in modern markets. Because more often than not, it's not through an exact replica of the castle, it's through insurgents. And allowing those insurgents to thrive in a free, durable, and uninhibited way, that's competition in a modern market. And that presents itself both in individual acts, it can present itself through a course of conduct. So that's the fourth pillar, and force section 2. The fifth pillar, at least that I'll discuss today, is to faithfully discharge the division's affirmative duty to prevent and restrain antitrust violations. Our duty is to litigate, not to settle, unless a remedy fully prevents and restrains a violation. It's no secret that many settlements, especially in the merger cases, fail to preserve competition. Even divestitures may not fully preserve competition across all its dimensions in dynamic markets. And too often, partial divestitures ship assets to buyers, often private equity firms, who are incapable or uninterested in using them to their full potential. At the Department of Justice, we are law enforcers. It is not our role to micromanage corporate decision-making under elaborate consent decrees. It is our job to enforce the law. And when we have evidence that a defendant has violated the law, we will litigate to address the entire range of competition, harm to competition. And in mergers, that will almost always mean seeking an injunction to stop the anti-competitive conduct and block the anti-competitive merger. But my emphasis on litigation is not just about institutional competence. It also supports the goal of ensuring that the language of antitrust reflects how people think about competition and ensuring that the law keeps pace with market realities. If we do not bring cases, the law will stagnate. Even as our economy undergoes revolutionary change, over-reliance on settlements will leave us governed by yesterday's law. We need to bring cases to enable courts to wrestle with the realities of today's markets and ensure that antitrust law is fit for purpose. That is point 5, litigate. Congress designed antitrust law to play out in the courts, before judges and juries in an open forum. So I want to end my prepared remarks by reflecting on my duty. I swore an oath to uphold the antitrust laws. And just last week, I appeared before a federal court in Denver, where I explained just how seriously I take my obligation to protect the American public. Antitrust is a kitchen table issue. The public depends on us to police the channels of commerce against collusion and monopoly. When we fail, families struggle to afford groceries. They earn lower wages. They lose control over their own private data to dominant platforms. The American dream slips away. That is why the Department of Justice must zealously protect competition. I'm hopeful with a healthy diet, steady exercise, regular checkups, I have a feeling that the patient will continue to live a long and healthy life. And I look forward to doing the work.